Assalamualaikum. We are Group 7. We present about industrial relations in Malaysia. This is our team member. First is me, Nuri Intakisina binti Nazim. Second, Nur Azika. Third, Humi Humaira. And lastly, Nur Hayun Hayariah. Table of content. First, introduction. Second, legal framework. Third, guidelines for industrial dispute resolution. And lastly, case study. Firstly, introduction. Next, what is industrial relations? Industrial relations is a relationship between the employers and employees. It also refers to a field of study that examines this type of relationships, especially groups of workers in unions. Next, important to resolve disputes in the workplace. First, can improve morale. Addressing grievance fairly helps boost employee morale and foster trust between employers and employees. Second, promotes productivity. A conflict-free workplace allows employees to focus on their work, improving overall productivity and efficiency. Third, ensure legal compliance. Resolving dispute in accordance with labor laws, ensure compliance, and minimize the risk of costly legal action or penalties. Fourth, enhance workplace harmony. Effective dispute resolution strengthens relationships, promotes teamwork, and creates a more collaborative and respectful workplace culture. And lastly, reduce turnover. Addressing workplace issues yearly helps retain talent and reduce employee turnover by showing commitment to fair treatment. And then, how do unresolved disputes affect productivity? Firstly, decrease employee morale. Unresolved conflict can lead to frustration, dissatisfaction, and disengagement among employees. Second, distraction from work. They may spend time gossiping, complaining, or focusing on the issues rather than working, leading to lower efficiency and output. Third, poor teamwork and collaboration. Without effective communication and cooperation, project may be delayed and team-based productivity suffers. Fourth, negative impact on workplace culture. A negative culture can lower employee engagement and create a sense of insecurity, further eroding productivity. And lastly, increase absenteeism. Employees who are unhappy due to unresolved conflict may take more sick leave or time off. Avoid the workplace. That's all from me. Thank you. So I will pass to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Azika binti Abdullah. My metric number is F1095. Today, I would like to explain about legal framework. What labor laws apply to industrial disputes? Industrial Relations ACT 1967 IRA. The Industrial Relations ACT 1967 is the central piece of legislation governing industrial disputes in Malaysia. It lays down the procedures for resolving disputes between employers and employees, including the information of trade unions, the recognition of collective bargaining agents, and the settlement of disputes. We go to the next slide is what are the rights and responsibilities of employers, employees, and unions in disputes. Employer rights and responsibilities. As you can see, for right, number one is management and control. Employers have the right to manage and direct the workforce, make decisions about the operations of the business, and set policies for the workplace. Number 2 is set terms of employment. Employers have the right to determine wage, benefits, and working conditions within the limits set by law or a collective bargaining agreement. Number 3 is enforce discipline. Employers have the right to enforce company rules, discipline employees for misconduct, and terminate employment for valid reasons, such as poor performance in subordination or violations of workplace rules. Other than that, for responsibilities, good faith negotiation. When a collective bargaining agreement is in effect, employers are required to engage in good faith negotiation with unions and workers over pay, working conditions, and other employment requirements. Number 2 is provide safe working conditions. Employers are responsible for making sure that the workplace is safe, adhering to health and safety regulations, and providing workers with the necessary tools and training. Lastly is non-discriminatory practice. Companies are required to abide by anti-discrimination legislation, treat every employee equally, give them equal chance, and refrain from taking adverse action against them if they exercise their right. Next is for employees' rights and responsibilities. We go to the right for employees. Number 1 is right to join a union. Employees have the right to form, join, or participate in a union without fear of retaliation or discrimination by the employer. Number 2 is right to fair treatment and equal opportunity. Employees have the right to be treated fairly without discrimination based on race, gender, religion, disability, or other protected characteristics. Number 3 is right to safe working conditions. Employees have the right to work in a safe environment and report hazards without fear of retaliation. Then, their responsibilities are respect workplace rules. Employees must follow the established workplace policies and rules unless those rules violate labor laws. Second, duty of loyalty. Employees are expected to act in the best interests of the employer, including performing work duties efficiently and avoiding conflict of interest. Lastly is they can participate in good faith bargaining. While employees cannot bargain individually in unions setting, they have a responsibility to support and participate in the union's bargaining process. We go to the next slide. For unions' right and responsibility. Right. The right to represent members. Unions have the right to represent their members in negotiation with employers, including collective bargaining and grievance procedures. Second, right to organize. Unions can organize workers and represent them in negotiations for better working conditions. They can also engage in activities like picketing, if legal, to support their cause. Number 3 is right to receive information. Unions have the right to request and receive information from employers that is relevant to bargaining or maintaining workplace standards, including financial data in some cases. Then, responsibilities for unions. Duty of fair representation. Union must represent all members fairly, regardless of whether they are paying dues or actively involved. They must not discriminate against any member and should act in the best interest of the group. Number 2 is compliance with the law. Unions must operate within the confines of labor laws, including respecting picketing rules, avoiding disruptive tactics, and adhering to legal procedures for strikes and other collective actions. Lastly is maintain order during disputes. Unions are responsible for ensuring that their members do not engage in illegal or violent activities, such as sabotage or picket line violence during a labor dispute. What are the legal procedures for initiating and managing dispute resolutions? The legal procedures for initiating and managing dispute resolution between employers, employees, and union depend on the jurisdiction and the nature of the dispute. Number 1 is filing a grievance. Grievances. Employees or union may raise issues through a grievance procedure defined in a collective bargaining agreement CBA. A grievance might involve violation of terms in the CBA, workplace safety concern, or unfair treatment. Number 2 is internal process. Before resorting to external bodies, employees and unions are often required to follow the grievance process outlined in the CBA. This could involve submitting a formal complaint, holding meetings with management, and attempting to resolve the issue internally. Lastly is time limits. Grievances usually need to be filed within a specific time frame after the issue arises, often within 30 to 60 days. Through this varies by jurisdiction. That's all from me. Thank you so much.
Hi, my name is Nur Hayin Hadawiyah binti Dollah and my matrix number is F1042. Okay, I will continue the presentation. I will talk about guidelines for industrial dispute resolution. Negotiation and mediation. First, what role does negotiation play in resolving disputes? Direct communication. Open the doors for honest conversation between employers and employees or their representative to sort out issues and find common ground. Second, cost effective and time saving. Save everyone from the hassle and expense of drawn out legal battles or formal arbitration. Get things resolved faster so you can move on and focus on what really matters. Okay, second, what strategies can be used to promote constructive communication during negotiation? First, active listening. Fully focus on the speaker and understand their message before responding. Avoid interrupting while they are speaking. Second, show empathy. Acknowledge and validate the other person's feeling and or concern. And second, showing empathy helps people feel heard and valued. Next, I will talk about legal proceeding and how does the legal process work in industrial disputes. Okay, first, informal resolution, attempt to resolve the issue through discussion, negotiation, or mediation. Second, formal complaint. If informal resolution fails, a formal complaint or grievance is filed. Third, mediation, or conciliation. The neutral third party helps the parties reach a settlement. Fourth, arbitration. If mediation fails, the dispute may go to arbitration where a decision is made. Next, litigation. As a last resort, the case goes to court for a legal ruling. And for the last one is enforcement. The decision must be implemented and followed by both parties.
Assalamualaikum, my name is Humaira binti Hussein, number matric 06DSK222F1080. So today I want to share about a state real life example of industrial dispute in Malaysia. A notable real life example of an industrial dispute in Malaysia is the Malaysia Airlines System Berhad and National Union of Flights Attendants Malaysia. This dispute began in 2030 when uniform representing cabin crew members accused mass of unfair labor practice include retirements of union members, discrimination against union's employer, non-recognition of uniform as a legitimate union to represent its member. And this is the resolution process. The debate occurred and was referred to the Industrial Court of Malaysia, which is handle labor dispute. Key step in its resolution. First is conclusion effort. Initial mediation by the Department of Industrial Relations field. Second is industry court hearing. Events and agreement we are present by both sides. The court ruled in favor of uniform, citing unfair labor practice. Third is court decision. Must was direct to restrict or attend employer. And the last one is appeals. Must appeal by ultimately complain with composition orders. Outcome and lesson learned. So the outcome is financial compensation for retrenched employer must improve its employer relation strategy. The lesson learned is important of organizing unions. The second one is role of the industrial court in safeguarding employer rights, and the last one is need to fair and transparent labor practice. And the conclusion is the mass and uniform case highlight the importance of upholding labor rights and the effect role of major legal machines in resolving industrial. Despite that's all from me. Thank you.